just talk first about the $154 million settlement with JPMorgan. How different is this from the Goldman Sachs settlement, other than dollar amount, or how similar is it?
Well, I think the similarities are apparent. Both cases allege that the investment banks failed to disclose to investors that a hedge fund who had economic interests that were contrary to and adverse to the investors were permitted to select the assets in the CDO portfolio. So the investors, thinking that they were invested in something that had an independent collateral manager who owed them a duty to select assets that were in their interest, instead didn't know that behind the curtain there was a hedge fund with very different interests who were permitted to help select the assets. So in that sense, the cases are similar, and both companies paid significant penalties, many multiples of the amounts that they earned on the deal, and I think that's the message.
JPMorgan has come out since the settlement and said it believes this matter resolves all of the SEC's outstanding inquiries when you look at their CDO business. Is that the case, Rob?
Well, I think it's fair to say that JPMorgan had a small CDO business, and based on what we know now, I do not expect further charges to be filed.
You know what I find interesting looking at this settlement is that no individual JPMorgan banker has been charged. At Goldman Sachs and the Abacus charges, you had Fabrice Tour. Why have we not seen an individual at JPMorgan charged in this case? Is it lack of evidence? Is it what's the reasoning behind it?
Look, we start every case looking for the responsible individuals. It's the first step for any prosecutor or enforcement authority. It's in the DNA to identify the individuals. We understand the benefits and the justice associated with that. But having said that, individuals present different circumstances, mitigating factors, litigation risk, defenses that may be shared by the company or may not be. And so you can't paint with a broad brush. You have to look at each individual case, roll up your sleeves, and decide whether or not the evidence is there for a particular individual.
And Rob, as part of this settlement, JPMorgan has agreed to improve how it reviews and approves mortgage-backed securities. The question is, outside of the nearly $154 million fine, which isn't really, going to dent their bottom line in the end, what does this mean in terms of broad changes in practice at JPMorgan?
Well, first of all, we say the money's not going to dent. That's true, but you have to keep in mind that, as with Goldman, the correct measure of the penalty is really a function of how much money was earned on the deal. And in both cases, they earned relatively small amounts for structuring fees, but paid penalties far in excess of that. So I think that's the right prism through which you should look at these penalties, not whether or not, given the entirety of the assets or the balance sheet of a bank, whether or not the money makes a difference. The fact of the matter is no risk manager is going to do a deal where they stand to gain a few million if there's a significant risk of tens or hundreds of millions of dollars in penalties. But second of all, you're right. The reforms and undertakings that we required as part of the settlement require JPMorgan to look at its processes for CDO and RMBS transactions and make sure that the approvals and the disclosures and the policies are fulsome and accurate, so we don't have another situation where investors are misled about what they are buying. In addition, the role of lawyers is going to be examined to make sure that they're fully involved and are reviewing this information, and that employees undergo additional training to sensitize them to make sure that the disclosures are proper.
So looking at the broader picture outside of, we have now Goldman, JPMorgan, Wachovia, the question on everyone's mind is this the beginning of just a flood of these cases and subsequent settlements that we're going to see from the SEC?
Well, first, I think you left a few names off the list. You did include the CDO cases, but keep in mind, we've been very active across the mortgage spectrum. So we have filed cases against mortgage issuers, such as Countrywide, New Century, IndyMac, against fund companies who loaded their mutual funds with mortgage securities and didn't disclose that to investors, such as Charles Schwab and Evergreen and State Street and Morgan Keegan. And down the line, ICP, a collateral manager out of New York for conflicts of interest in managing CDOs, Citigroup for its subprime disclosure, Colonial Bank for TARP fraud and mortgage fraud. So we're active across the entire mortgage spectrum. With respect to future cases, all I'll say is what we've said in the past, which is This is and remains a high priority for the Commission, and we're going to continue to look closely at these transactions and at this sector.
Rob Khuzami, thanks so much for your time. I appreciate it.
You're welcome. Thank you.